Well, good afternoon, everybody, and welcome back. I have a few housekeeping items before we get started. First of all, polls are going to be sent out for CE purposes. Please answer the questions that pop up on the screen so you are eligible for your CE credits. And once again, a heartfelt thank to our sponsors for their support of PAMIC, of the industry, and of our educational outreach. All the presentations that you have seen and will see for the rest of the day will be available on the PAMIC website. There'll be a link to them sent after the conference is over. So we have a very interesting start to our afternoon. And the name of the session is Injury Claims from the Plaintiff Counsel Point of View. And Peter Speaker and Scott Cooper have put together a very interesting and like fact-filled presentation, and it'll be a very busy 59 minutes. Pete's a partner in the law firm of Thomas and Hafer, an insurance defense firm with offices throughout Pennsylvania, Maryland, New Jersey, Virginia, and Washington, D.C. He's a past president of the Pennsylvania Defense Institute and a longtime member of PAMIC's Claims Committee. Pete focuses his practice on representation of insurers in UIM, PIP coverage, and bad faith matters. Scott Cooper of Schmidt Kramer is a partner at the Harrisburg-based personal injury law firm, where he specializes in personal injury law with an emphasis on motor vehicle accident and insurance cases. An active member of the Pennsylvania Association for Justice, he served as its 2012 to 13 president and is currently chair of its legislative policy committee. He's been named by Pennsylvania super lawyers as one of the top 100 lawyers in the Commonwealth every year since 2011. In fact, he's been selected for inclusion as a Pennsylvania super lawyer every year from 2006 to the present. He's also been named to the best lawyers in America each year since 2012. Mr. Cooper has been actively involved in many important appellate cases in the Pennsylvania Supreme and Superior Courts and United States Court of Appeals for the Third Circuit, including Gallagher versus GEICO, Rush versus Erie Exchange, Rankowski versus Washington National. Okay, you get the picture. Welcome, Scott and Peter, and I'm handing it over to you.
Thanks, Sarah. Thanks, Pete, for asking me to do this. This is really a privilege. Just want to make sure my screen is being showed. Okay. We had this before. Oh, there it is. Okay. So thanks again, everyone. So we're going to go quick, and what Pete and I are going to do is a point counterpoint. If anyone has any questions, please put them in the Q&A, and we'll try to cover them in the hour. If anyone has any questions that you want to email me, feel free, and we can. I'll send you anything you need. So first, statute of limitations, and this comes up a lot in at least our cases. Internally, my goal is to never miss a statute of limitations. And I think what a lot of times, at least from my perspective, you see is from a plaintiff side, bad facts make bad law. And whether someone would agree with the Bristol case, which Pete's going to explain the potential counterpoint and how this could actually play out, is you had a case in Bristol where there was an underinsured motorist claim and there was ongoing negotiations for over 4 years. And there was a case back in the late 2000s State Farm v. Rosenthal, where the Third Circuit said that the statute of limitations for a underinsured motorist claim is 4 years from when you settle the case. And there was always this question about when the statute ran and when it didn't run. And then in Bristol, this was like the perfect storm. Basically, the two sides are negotiating for about 4 or 5 years, and then they reach an impasse, and then Bristol files a lawsuit against Erie. Erie goes in and says, you blew the 4 years, and the Superior Court said yes. In the Supreme Court case by Justice Mundy, she said you look at the date of the denial or the date of the breach is when the statute of limitations starts. So it's where you really end up at an impasse. Now, Pete will talk about the counterpoint. I always usually tell lawyers when I speak to them that generally what I would do is you take 4 years from when you settle the underlying case, and to be safe, either when you get close to the 4 years, you either file a writ, file a motion to like compel arbitration or something, or I think the easier thing is asking the insurance company if they'll agree that you've told the statute of limitations by at least opening the file. And, you know, I think, Pete, what I'd like to know is if you agree with that also, at least as far as having like a tolling agreement, so you don't end up in court when you're doing the counterpoint on this.
Yeah, I would agree with that, Scott. And from the plaintiff's perspective, the earlier the better. And usually you're going to get an agreement from the insurance company because the alternative is a suit. So
Right.
on the Bristol case, I think Bristol is a one more example of bad facts and broad statements, perhaps creating some bad law. The actual holding in Bristol was that the statute of limitations is commenced upon an alleged breach of a contractual duty, which in that case was a denial or a refusal to arbitrate. It's a bad case. What actually happened in that case is that the claimant and the insurance company named arbitrators. And my understanding is they named their arbitrators within 4 years of the accident. And the claimant argued that that should be enough to toll the statute. And frankly, the court should have decided on that basis, but instead made some unfortunately broad statements. And from our counterpoint is that a denial or a breach cannot be required to start the period of limitation, because then you have practically no limitation at all. Suppose, for example, someone has an accident and makes no claim for 10 years. And then they make a claim and it's not paid. Let's say it's the insurance company doesn't respond for 10 more years. And then 20 years after the accident, they file a suit. Well, if you accept the Bristol case literally, at least a broad reading of it, they don't have a statute of limitations problem. And I would just submit that that's ridiculous. If you get in the next slide, Scott, I would submit that everybody's had it wrong all along. That the statute of limitations in a UM or UIM case, the running of it, the commencement of it, ought to be no different than in any other case. When you can sue is when the statute should begin to run. And so I would argue, and given the opportunity, will argue, that the court really needs to ask itself only one question, and that is, if suit had been brought more than 4 years ago, would you have dismissed it as premature? And if the answer is no, then it's barred by the statute. So Interestingly, the opinion in Bristol recognizes that that's the general principle in statute of limitations cases. It begins to run as soon as the right to institute a suit arises. Let's take a case. If you sued for uninsured motorist benefits the day after the accident, they would not throw your suit out. Scott?
So, yeah, and a couple other things before we move on to everyone's favorite topic in the last couple of years, is like Pete and I have a case now where it's an underinsured motorist forms case, but like Pete said, one of the arguments, at least that he's fighting us on, is we're saying the statute of limitations only goes back 4 years. It could go back indefinitely if the people never made a claim for the coverage. And Pete's saying, well, it's only 4 years from when you bring the case. Also, for a lot of companies, there are still some companies out there. So you need to, depending who you're representing and what policies you put out, where companies still have for underinsured motorist coverage, it says the claim has to be brought within 2 years of the date of accident. And I think that gets companies in a lot of trouble. It's usually the companies from out of state that don't write a lot of coverage in Pennsylvania, but they're coming in with like, not ISO forms per se, but like forms they use in all these other states. And we've been finding them on the insurance department website that every once in a while it gets through, where there's a 2-year statute of limitations. And it really is 4 years. This contract can't restrict what the law would be anyway. Pete, would you agree with that?
No.
On the 2 years?
I have not researched it, frankly. I know that in certain insurance contracts, there are period of limitation clauses that are regularly enforced.
Right, like 1 year for the fire you can do. But in any event, we go point, counterpoint, call Pete on the 2 years. So household exclusion, my Gallagher case. So just by way of background, for those of you who aren't familiar, the household exclusion basically involves different cars in the household that or motorcycles and cars that are split on different policies. And by way of history, the cases generally, the perfect example is I have a car and then I have a daughter or children in the house and they have a car or even 2 cars, and the policies are split either between the same company or 2 different companies. And on both policies, I may have stacking, I may not have stacking. And if, for instance, one of the kids is in their car that has the 2 cars on the policy, and they're, God forbid, catastrophically injured or in some way, they collect the benefits on those 2 cars, then you want to go and make a claim on my car since they're a resident relative and they live in the house and they're stacking. The household exclusion basically prevents coverage on my single car policy because they were injured while occupying or driving a vehicle that they own that's not insured on the same policy. And this was going up, this exclusion was upheld for over 20 years. Initially started out as a limited exception in a case called Eichelman, which we'll talk about in a little bit. But prior to 1990, the coverage was mandatory for on and under, so the exclusions never came out or came up. Then in 1990, the coverage became that you can reject it. Gallagher, I think from a plaintiff standpoint, was basically the perfect storm to challenge the exclusion. In Gallagher, Mr. Gallagher had 2 motorcycles insured with GEICO that he had stacking. He also had 2 cars with GEICO that had stacking, but they were on 2 different policies. he makes a claim when he's injured on his motorcycle with GEICO and gets the coverages for both motorcycles. He then goes to his household policy with GEICO and says, I want the coverage there. I'm paying for stacking, and you know about my cars. It's the same company. GEICO had split the policies. GEICO said, well, there's 3,000 cases that say we don't have to pay you because you were operating the motorcycle that was insured that's not on the household car policy. And the trial court upheld it, the Superior Court upheld it, but then the Supreme Court accepted the case. And there were two issues. One is the first issue you see in front of you, where if it's the company split the policy, and it was in the record that they had unilaterally split the policies, GEICO. And the reason they did it was because it wasn't in the record, but this was basically the reason, is GEICO insures household vehicles on 6-month renewals and motorcycles on 1-year renewals. And the reason they do it in 1 year for the motorcycles is they don't want people uninsuring their motorcycles in the winter, basically. But one is on a 6-month, one is on a 1 year. The person paid for stacking, elected stacking. And the argument I've been making is the household exclusion narrows and conflicts with the mandates of the law. The reason it violates it is because the law says you as the insured automatically have uninsured and underinsured motorist coverage and stacking unless you reject it. And there's only one place in the statute, 1731D, where there's a limitation on recovery, which that's really an exclusion. It's a limitation on your ability to recover. And therefore, the household exclusion, whether it is in accordance with public policy, whether there's 3,000 cases, it is invalid as a matter of law because it basically is a backdoor anti-stacking provision. That basically, if you pay for stacking, you've paid to go both intra-policy, where Mr. Gallagher was getting for both the motorcycles, but also inter-policy stacking. And the Supreme Court in Gallagher in January 2019 said it violates 1738. We argue it applies to all cases because if you look at, there's a few other cases we'll talk about, Luce and Root. Pete disagrees. There's a case out of the Western District that's called Barnard versus Travelers. And that was a case where the Western District said, well, it's a regular use exclusion. And it was really, when you look at the facts of the case, it was really a household vehicle. So that was really more semantics, and that case settled. Now, the regular use exclusion is a whole different exclusion we'll talk about. That's really more the company car or the police vehicle or the UPS vehicle. So that case settled. So there was never a decision from the Third Circuit on that. As far as subsequent major cases, and then Pete will talk a little bit about the defense perspective. Stockdale's an Eastern District case that we had filed a class action. Judge Beetlestone found that it applies in whether or not you have the same company in the house. It could be different companies. Also, she found that it applies to the vehicle that you're making the claim on. So you don't look at what vehicle you already got the coverage on. You look at if you bought stacking on the vehicle you got the claim on. Petrie and King have basically been mooted out, which I'll explain in a minute why, by a new case that actually came out Monday. That's a published decision that you're going to want to know about. But Dunleavy is a Third Circuit decision that sets the stage for what we'll talk about Mion. In Dunleavy, this is a case you want to know about, was on a motorcycle. he gets injured in the accident, and he had rejected and underinsured motorist coverage on his motorcycle. He then wants to go to his household policy with New Century, saying, I bought underinsured motorist coverage. I bought stacking on that policy. I should be able to get underinsured motorist coverage on that policy, citing Gallagher. New Century says no, because you never had coverage on your first policy. Therefore, there's nothing to stack. And the Western District Court relied on probably one of the first household exclusion cases called Eichelman, and said Eichelman has nothing to do with Gallagher, and therefore he doesn't get the coverage, and therefore also they dismissed the case. The Third Circuit relied on, basically followed the Western District case. The case you want to know about in the state court that just came down is Erie versus Mione. And that was a Superior Court case by Judge Bender that just came out on Monday, and it's published. And that's the same facts, but it's a really good opinion, at least that's published. Whether or not when we file an allowance for appeal, it gets accepted or whatever. But if you're looking for a good analysis of what is Gallagher and what is Eichelman, Judge Bender goes through it. He basically is saying the reason why Mione can't get the coverage on his household car policy is because he didn't have coverage on the motorcycle he was on, and therefore there's no stacking. You really can't stack a second policy on nothing. There is a footnote towards the end where he does acknowledge that if Mione had coverage for uninsured and underinsured on the motorcycle, then he would have been in Gallagher, and then the exclusion may have been invalid. So when you're looking at these household exclusion cases and stacking, you want to be careful about what the underlying car is too, or motorcycle. But now Pete's going to tell you why I'm totally wrong.
I think Scott did a good job of covering what those courts have said in those cases, but make a few comments about Gallagher in general and some of its background and what it means. Let me start by making a comment about the household vehicle exclusion, because we don't want to lose sight of it. It's a very logical, simple exclusion that in effect says, get your UIM from the company you picked to insure that vehicle and the company that you paid for the insurance on that vehicle. It's a very simple exclusion and very reasonable. Gallagher was a radical departure from prior law and from logic, I think. Before Gallagher, it was absolutely clear for decades that there are certain legitimate exclusions to uninsured and underinsured motorist coverage, such as the household vehicle exclusion. And it was also clear for a long time that the right to stack coverage was the right to stack coverage that applied. That the right to stack did not create coverage that didn't exist. Gallagher was an example, again, of the old saying that bad facts make bad law. As Scott indicated, it presented a very unusual fact scenario where a single insurer covered multiple vehicles, sold stacked coverage on all the vehicles, and then insisted that they be on separate policies, and then turned around and said that because they're on separate policies, you're excluded. As Scott said, that was a perfect storm. And I congratulate him on the selection of that case to take to the Supreme Court, because that has some gut appeal. The actual decision in that case is quite understandable. But the brilliant Mr. Cooper managed to convince the Supreme Court to make some astoundingly broad statements. such as, and this is a quote from the beginning of the case, "We hold that the household vehicle exclusion violates the MVFRL," close quote. And some courts seem to have taken that statement literally. Scott may even agree with me when I say, one thing that's for sure is that's not true. That is not the holding of the case. The household vehicle exclusion is not invalid in all scenarios. I think Scott may agree that it's certainly not invalid in cases where the insured or the policyholder rejected stacking. Gallagher is a stacking case. He may not be willing to say that on the record, but he's going to have a difficult time arguing that it's invalid in the case of unstacked policies. So I think one thing that's certain, at least at this point, based on the current state of the law, is Gallagher does not necessarily mean that quote, the household vehicle exclusion is invalid, even though that's what it says. At this point, we're going to go over some of these cases. We have some pretty good trial court opinions and substantial appellate authority, although not Supreme Court authority, for the proposition that Gallagher does not apply to certain scenarios. It does not apply to the regular use exclusion. I think 6 out of 7 trial court decisions that I'm aware of go that way, although some of them are on appeal. It does not apply to unstacked policies, and there's several trial court opinions on that. According to a recent Superior Court decision, it does not apply to claims by guest passengers. That is, people that are injured while in a vehicle that is not owned by them or a family member. It doesn't apply to injuries sustained in vehicles that don't have UM or UIM coverage, and that's the Mione decision that just came out this week that Scott told you about. So I think in general, my message is don't give up on these cases. Who knows how they're going to turn out? This case law is still developing, but it's certainly not true as a general proposition that the exclusion is invalid in all cases. I think there's still room to argue, particularly in the Supreme Court, that Gallagher should be limited to its critical facts. As indicated, one insurer, all stacked policies, the insurer put them on separate policies and then excluded coverage on that basis. That was the issue accepted in Gallagher, and my contention is that's what was decided in Gallagher. With the next slide. Now, unfortunately, in the opinion, Justice Baer did make some statements about suggesting that the exclusion is invalid even where there are multiple insurers involved. My argument is that was dicta, that issue was not litigated, and that the dicta was based on a misunderstanding of some of the realities of insurance processes. If we can get a next slide, Scott. For example, one of the things the justice says, well, if you want to know what's going to be covered, one of the arguments from the insurance companies is you shouldn't make us provide coverage for vehicles in the household that we don't even know about. And I think Justice Baer said at one point, well, all you have to do is ask. The reality is, and people who do this often are exposed to this all the time, is that changes are being made all the time. Vehicles are being added and deleted. People are getting driver's licenses that didn't have them before. People are coming in and out of the household. And certainly you can't disclose things that haven't happened yet. So you can't disclose risks that aren't there yet. Next slide. I think we talked about this already. The Gallagher does not, and the opinion itself says so, does not address other potential exclusions, such as the regular use exclusion, which provides in most policies that you can't get UAM coverage while injured while occupying a vehicle that's available for your regular use. I think most trial courts have upheld that so far, but appeals are pending. Scott?
Yep. All right. And as what Pete was saying, first, obviously, I would disagree that the household exclusion, as Pete, is limited to the facts. A lot of people, generally, no one ever reads footnotes. I actually started a few years ago reading footnotes. I would say that footnote 8 from the opinion in Gallagher is important. It basically says, I'll read it. As in every case, we are deciding the discrete issue before the court and holding that the household vehicle exclusion is unenforceable because it violates the MVFRL. And then it says, if at some later date, we offer no opinion on the enforceability of any other exclusion to UM or UAM coverage or to coverage in general, including exclusions resulting from racing or inherently dangerous activities. And then they say, if at any other day, they'll look at the other exclusions. I would argue that this is saying that when you have the household vehicle exclusion, a household vehicle, and it could also be a regular use vehicle, not in the, when Pete was talking in a regular use case, but a household vehicle that's in your house available for the regular use. And I'll talk a different, what I think is the difference about that. But there's other exclusions that the courts would still look at. For instance, several years ago, the court invalidated the workers' compensation exclusion in the Heller case I did. So the court's looking at it on a case-by-case basis. There's a concurrence in Sales versus Allstate, if anyone's interested, where one of the justices specifically says the companies shouldn't try to rewrite Pennsylvania law because they're going to be setting these exclusions and provisions aside. So when you're looking at these other exclusions, they are going to be addressed probably on a case-by-case basis, but the same concept would apply, that if the law says you have to give the coverage, then you should get the coverage. Moving on to the regular use case, the regular use insurance case is the regularly used vehicle that the person generally does not own. And that, I think, is different than a household vehicle that's in the house when you're talking about a household exclusion, which is what Barnard was. But Rush versus Erie is the perfect case to talk about that. In Rush versus Erie, Mr. Rush was injured. He's a police officer working for a township, and he gets injured while working. He gets the third-party coverage from the car that caused the accident. The township vehicle then had $35,000 of underinsured motorist coverage, which he collected, and then he wanted to bring a claim with Erie for his underinsured motorist coverage that he had paid for stacking on a two-car policy. Erie said no, relying on the regularly used vehicle exclusion, which is basically saying we don't provide coverage when you're injured in a vehicle that you don't own that's available for your regular use. That's the UPS driver, the police officer, the park ranger, those types of vehicles. And there have been cases that have upheld it. We filed in Northampton County a cross motions for summary judgment with Erie, and we made two arguments. One argument is that, and this was the argument that the judge ruled on, that it violated Gallagher because he tried to get coverage on the first car, which he did. Now he's going for his household policy, and he paid for stacking, and he should get the coverage. Judge Barada found the exclusion invalid, and that's the only case so far that I've seen where the regular use exclusion has been set aside. And now that's pending on appeal, and it's scheduled for argument June 23rd in the Superior Court. So we'll have a decision on the regular use exclusion coming out probably by the end of the year. And then Pete has a counter.
Yeah, I think I talked about some of these already. Again, my point is there are exceptions to the suggestion that Gallagher invalidates the exclusion. So in Erie versus King, which was just recently, I think within the last month or so,
Yeah.
the court, it's a very complicated case if you are not intimately familiar with the history of UMUIM law, but the bottom line, Scott, I guess, is this a fair description? It doesn't apply to claims by guest passengers.
In this case, because he owned the cars, basically. And he was trying to say that he was a guest passenger on it. And that was the main, that he didn't have coverage on his first vehicle. So, so they didn't apply it in that case to the guest passenger. And this is, Pete, I guess, this is Eichelman.
Yeah. Right, that's the most recent case, right?
Right, and this was, when we submitted this, this was last Friday. So what you're looking at is Dunleavy was before this Erie versus Mione case. Mione literally came out Monday morning, so a lot of people don't even know about it. That's why it says that was when it was submitted back in last year. So, so this previous screen, I guess under published cases, they don't disagree at this point, that it wouldn't apply if you reject the coverage on your occupied vehicle because there's nothing to stack, basically.
Right. And the Mione decision, by the way, is now available on Lexus. It's a 2021 PA Super Lexus 288.
Right, and now at the same time, if for instance, Mr. Mione, for one, even though people mostly, it seems, get into accidents while they're on the motorcycle that would not have underinsured motorist coverage, if he was in his cars, he'd still be able to get the coverage on the Erie cars, whether or not he had rejected on and under on the motorcycle. And then there's another case that is being argued at the end of this month, Erie versus Sutherland. And this is an appeal from Lawrence County. And in that case, it was a motion for judgment on the pleadings. And the court invalidated the exclusion relying on Gallagher. And I'm assuming, Pete, your position is now, well, Mione would control.
That's our position. I don't know, Scott, do you sometimes get conflicting decisions out of the Superior Court?
Well, I would think I think in Sutherland, the one difference between Mione and Sutherland is Sutherland's a motion for judgment on the pleading. So just from a legal standpoint, I think you could make an argument that there has to be remanded to determine about the premiums, because I don't think Erie considers any other vehicles when they do their underwriting. For instance, in the regular use case, there's a case from 10 years ago, Adamitis versus Erie, where I had put in the record that Erie actually knew about the work vehicle that the person drove, and they didn't even consider it in the premium, and they still were able to enforce the regular use exclusion. So I think you can make an argument to try to fight the premiums about whether they knew about it or not, or took it into consideration. But I could definitely see, because it was a judgment on the pleadings, I think Sutherland still has a chance. So inter-policy stacking, this is a case you're going to want to be aware of that was argued in December. And this is going to be a case that deals with single car policies. If you go back to Crayley from back in the early 2000s, the Supreme Court at that point established what's known as intra-policy stacking, which is where you stack within the policy, and inter-policy stacking, which is where you go policies within the house or across multiple policies. And there was a concurrence by Chief Justice Cappy at that time, where he talked about that the form for stacking talks about multiple vehicles on a policy. And he suggested that the company should create another form for a single car policy, because there may not be a knowing and intelligent waiver on a single car policy. So for instance, in Donovan, Corey Donovan had basically two single car policies, gets in, and it rejected stacking on both, gets into an accident in his one car, makes a claim, then wants to go to State Farm. State Farm says, no, you had rejected stacking. And the argument was made, well, he only had rejected stacking on intra-policy because it was in the same house, not inter across both policies. The Middle District Court found that it could not be used on a single car policy, the rejection form. The Third Circuit actually certified the case to our Supreme Court, and the Supreme Court heard the argument in December. And if, depending how the court rules, if there's a single car policy, the person, until the new form comes out, may be deemed to have stacking. But I know Pete disagrees.
Yeah, we completely disagree with that. The reality is that the legislature enacted a statute that said you must use this form to enable people to reject stacking. The Supreme Court held that back in Crayley, the actual holding in Crayley was that insureds have the right to reject stacking even with respect to a single vehicle policy. That was the issue. So the law is that people have the right to reject stacking on single vehicle policies and on multi-vehicle policies. And the statute says you have to use this form. Insurance companies don't have the power to rewrite statutes. Our argument is this is the form that the legislature says we must use, and so we must use it, regardless of whether it makes sense, regardless of whether it's a good form. We don't have any choice. If you get the next slide, our argument is that the plaintiff's argument is a catch-22 for insurance companies, where there's a statute that says you must use this form, and you can't, and specifically says any other form is invalid. And yet the plaintiffs are arguing that you have to use a different form. It's a catch-22. It makes no sense. And going back to what Scott had said about the Crayley decision, my recollection is Crayley did not, well, first of all, the statements were dicta. That was not the issue before the court. And my recollection is the court said that the legislature ought to take another look at this. I don't think there's anything in Crayley that suggests that insurance companies have the right to ignore the statute and write their own forms. In any event, we're going to find out the answer in the near future, aren't we, Scott?
Yes, we will. And as far as Crayley, just by way of background, in Crayley, that was mainly a household exclusion case, but the Supreme Court never actually addressed the household exclusion issue. What they held was that you can waive inter-policy stacking, and it has to be a knowing and voluntary waiver. And what they found in that case was there was a knowing and voluntary waiver because of they had the same insured on both policies, the same coverages on both policies. They were in the same house. So they found it was presumed that there was a knowing and voluntary waiver of inter-policy stacking. And then suggesting that if anything was different, they may have remanded it back. So you still have that other issue floating out there. Mr. Sackett, from back in 2004, basically, and I know we disagree on this, but what the Sackett decision says is when you add a car to a policy, not if you replace, not if you delete, but if you add a car to a policy, and the car, and it's not being added under an after acquired vehicle clause, which is where you backdate the coverage, that the company needs to get a new rejection, a stacking form. And there's one case that we've had about the first named insured, this Rodriguez case, but by way, and basically in Rodriguez, if you look at the form, it says it has to be signed by the first named insured. And in Rodriguez, it was, I forget the order of the names, but basically the person who was listed first on the form never signed the form. It was signed by the second person, and the court said that's invalid. The main thing is this issue is actually ripe at some point, is going to come back. There's a case from 2001, Rupert versus Prudential, where the Third Circuit initially had the case. And the issue was whether it's the first named insured who signs a form at the inception of the policy or at the time of an accident, because Mrs. Rupert had taken over her husband's policy after they got divorced. That was one of the first cases to ever be certified by the Third Circuit to our Supreme Court. Our Supreme Court actually split 3-3 with one of the justices recusing. So you had 3 saying at the inception, 3 saying at the time of accident. And then the case was remanded back. The Third Circuit, and I remember they put in the opinion, we're basically writing in quicksand because we don't know the answer. So they split 2-1. And what the Third Circuit said is it's the first named insured at the inception of the policy. And then the dissent said at the time of the accident. So I always look if someone's rejected stacking, because every once in a while you have someone who they call up the agent, they say, all right, I want this. And then someone goes in and signs it, or a kid goes in and signs it. And they're not even a named insured. They're just by operation, they just go in to sign it. So I think it's important to look at, and Pete wholeheartedly disagrees with me on this.
This is another one of these cases where, unfortunately, sometimes the judge deciding the case is not familiar with the process of getting insurance. We should be very practical about this. When someone goes in to get an insurance policy, they fill out an application and they fill out some forms. As of that moment, there is no policy. There is no first named insured. And our position is that when you're presented with a set of papers that has a line on it that says first named insured, and you put your signature on it, you are the first named insured. If subsequently a policy is issued that lists someone else as the first named insured, I would say the appropriate remedy is to fix that and change it to the person who signed as the first named insured. This is a kind of case that the plaintiff's lawyers love. It's a gotcha situation. There's no reason why someone should get the benefit of a mistake in listing the first named insured after the application process.
And the reason to also you want to do that is because, just by way of example, if someone has 3 cars and they have 100,000 of bodily injury and someone signs a rejection form for on and under, if it's not signed by the first named insured, by operation of law, they automatically then have 100,000. But not only do they have 100,000, most likely they're going to have 300,000, because if they sign a rejection form, chances are the agent or someone never had them sign a rejection form of stacking, because they never were going to have stacking on something that they were never purchasing. So you want to be careful on that. And it's a lot of agents can get into, I've seen a lot of agents get into trouble with errors and omissions with the companies and stuff by not having it done right. The most recent Sackett case is Barnard versus Travelers. And that was where someone rejected stacking and then they increased the limit on their underinsured motorist coverage. So in this case, it was 100 of liability and 50,000 of UM and UIM, rejecting stacking. And then they increased the liability, the underinsured motorist to 100. And the argument was made, well, they needed a new rejection of stacking form. And this isn't even when you add a new car. And the reason we argued is because, again, the word purchase is different in 1738. It's not in 1731. It's not in 1734. So they never had the opportunity to purchase rejecting stacking on a $100,000 policy, only on a 50. And the Supreme Court said, yes, you need a new rejection of stacking form if you increase the UM and UI or UIM from the, even if you rejected stacking. So that's an important case.
I don't have much of a counterpoint on that, because that's what the case says. And that's the Supreme Court. That opinion, by the way, is at 216 A 3rd 1045. And I'll just add this comment. If you don't understand Scott's argument on that, then you're probably a normal person.
So for the abnormal person, we'll go on, and we're going to go a little quick to finish up. But the unlisted driver exclusion, this is the insurance companies. You guys won this one. Basically, you can say that if you have a household resident, that they all have to be listed in order to drive the vehicle. And if they're not listed, you could deny liability coverage. That's what happened in Orenthal, that Orenthal had a resident living with them who was going to drive the car, never listed him as a driver, and then got into an accident and the company denied the claim. You still could give permission to someone, but if they're living there at the time, you can require them to be listed. Now you get into a whole bunch of issues. Like Pete said, people change things all the time. So if they have someone living with them for a month, are they really a resident or not? But for lack of a better, I think what you need to do is at the beginning of every renewal, ask if you have someone who moved in who's going to be driving the vehicle.
It took us 55 minutes to find something we agree on.
And then just, this is important, you're going to want to know, especially because it's evolving and it's going to be coming up. The transportation or ride sharing, there was the law a few years ago that was passed on ride sharing. And those issues are starting to work their way through. But there's going to be, and if you look at the bottom of the slide, Toro, which is known as a peer-to-peer generally, which is really where people, it's not the company, it's not where Uber, where you have your driver and then the person gets in the car and then they're driving them around almost like a taxi service. In Turo, it would be where I want to make money on renting out my car, and I leave it, generally people leave it at the airport. You list your car on the app, and like someone who's getting off a Delta plane can rent my car and drive it around for a period of time. There's going to be a lot of issues that are going to start popping up. If there weren't enough with Uber where you had two policies because you had the Uber driver and you had the Uber policy, here you're going to have potentially three policies. You're going to have the person who's renting out the car, which is probably going to have an exclusion for a fee exclusion. You're going to have the person who's renting the car, whether if they cause an accident, whether their policy is going to apply. Then you have a Turo policy, because they always offer a policy, and they always tell you when you rent the car, don't buy the rental coverage because it's a temporary substitute vehicle, but you may need to have the rental car. You know, this is a rental car, for lack of a better term. And then even as I'm sitting here thinking this through, you're going to have potentially fourth car, because say you have a passenger, and a passenger who just is driving around, they're going to have an issue potentially for liability, uninsured, underinsured. So there's legislation that Representative Nelson in the Pennsylvania State House is trying to introduce, that's going to cover a lot of this stuff. There's been some states around the country that have passed legislation. But if you're looking for like the next developing area that you're going to have to worry about, and you're going to have to hire Pete to defend you on, that's going to be the next area, is probably the peer-to-peer and the Toro areas. Pete, anything on that?
No, I agree. It's going to be complicated.
It's going to be crazy. And then we're basically done with the hour. And I just wanted to say, you know, we also have issues, you know, I may be abnormal and stuff, but, you know, these are the different things that I hear from plaintiffs' lawyers, that, you know, we do have crazy clients. You know, it's a lot of times I say, you know, give me pay up front and it's going to save you money on the back end. Some people make reasonable demands, some people don't. I'm not in Philadelphia, so I think mine are all reasonable. I know Pete disagrees on that. The recorded statement and the IME, but I know Pete has one gripe about plaintiffs' lawyers, I guess, or whatever. And, you know, I'll just let Pete finish up, but it was a pleasure, and thanks again.
Now, I would say from the insurance defense point of view, my counterpoint is that, I don't know, Scott, our clients are all intelligent and reasonable. We don't have any problems like that. But I do want to thank you for your time and effort here. This was, I think, very illuminating for us. Thank you.
Thanks again. Thanks, Pete.
I don't see any questions. So I think, Sarah?
Yes, I popped up again, and it's time for a 15-minute break. Thank you so much, Scott and Peter. That was really fascinating. I like your gentlemanly counterpoint, and you know, the way that you put this together. I think that it was very helpful to all of us, and thank you very much. So we have a 15-minute break. We'll get back together again at 2:15, And that will be our last session. We'll be talking about dogs. When Fido Gets Feisty was the original one, and now we're talking about Rover's Rampage. So see you then.
We'll have to take that show on the road.
Yeah. Huh.
Thanks.
Running a business is more challenging than it has ever been. We know staying competitive and driving your business goals are your top priority. But the cost of compliance is going up, while internal time and resources are going down, all while the cost of an hourly attorney and consulting fees continue to rise. And with those rising fees, you still have limited accessibility and less than ideal response time. So where do you go for answers so you can quickly get back to achieving your business goals? Enquiron is here to provide you with an on-demand, accessible, and easy-to-use solution that you can begin using immediately. It takes just 1 minute to register. Get unlimited support from our client services team. Save an average of $12,000 annually. Oh, and stay in compliance. Sound too good to be true? Well, it isn't. You get unlimited access. Get started today. And suddenly, the path toward compliance isn't so challenging. In less than 1 minute, you can log in or register and be on your way. Stay focused, stay competitive, and drive your organization's business goals. Let Enquiron help with the rest. Our client services team is standing by to answer any questions you may have. Turn your questions into answers.
What's the best way to protect your business? With Donegal Insurance Group. You've poured your energy, your passion, and your heart into this business, and you want it to succeed for generations to come. That's why our agents partner with you to ensure and protect what you've worked so hard to create. Protect your business. Protect your future. Visit DonegalGroup.com/protect to connect with an agent today.
Hey, Scott.
Hi, Dale. How are you doing?
Yeah, pretty good.
Long time no see.
Still 60 participants listened, so I guess not too many people have filtered away.
It's because we're about to give a entertaining and riveting performance.
Absolutely. Hey, Scott, I'm going to do my best to finish up right about 3. Does that give you sufficient time?
I will work with whatever we have.
Okay. Hi, Sarah.
Hey, Scott, good to see you. Hi, Dale.
Hello.
Well, our session is slated to start at 2:15 and it is now 2:15. Welcome back, everybody, for our last session. Well, this one sounds like lots of fun. Rover's Rampage and how not to get bitten during the claim. This was formerly known as When Fido Gets Feisty. I kind of like that name too, but we'll stick with Rover, who I'm sure is a very good dog, and he's never done anything bad before in his life. So at any rate, we have 2 distinguished practitioners to walk us through the intricacies of dog claims. Dale Forsyth is a longtime AV-rated member attorney at the Pittsburgh law firm of Wayman, Irvin, and McCauley. In addition to state and federal courts in Pennsylvania, Dale's also licensed to practice in Ohio and West Virginia. After earning his JD degree from Duquesne University School of Law, where he was an editor and contributor for the Law Review. See, he was an overachiever even back then. His career has focused for 35 years on insurance defense litigation. Dale's been an active member of various insurance industry organizations over the years, including the Pennsylvania Claims Association, RIMS, CLM, DRI, and of course, PAMIC, where I might add he's been a faithful member of the committee for quite a while. In addition to serving on the Professional Liability Specialty Board of Editors for CLM's Journal of American Law, Dale's authored numerous articles for various industry group publications. He's been a frequent presenter on a wide range of insurance-related topics for many carriers and brokers, as well as for insurance industry and other professional groups. Scott Ribney is a partner and chair of Morgan and Aiken's Insurance Coverage and Extra Contractual Liability Practice Group. He's devoted his entire legal career to representing insurance carriers, agents, and third-party administrators before trial courts, appellate courts, and arbitration panels in various high-stakes litigations. His practice focuses on matters involving various forms of commercial general liability. This is too much. Involving various forms of commercial general liability, fiduciary liability, professional liability, and commercial crimes policies. With 20 years of experience, Scott's knowledge of the business of insurance gives him the unique ability to advise and counsel insurers on corporate and policy-related issues even before litigation arises. There's going to be a Q&A. There's a Q&A function in the bottom of your screen. If you have any questions, just put them into that Q&A queue, and if time permits, Dale and or Scott will answer the question. So without further ado, let's hear about the damage that Rover has done. Good boy that he is. Take it away, guys.
Hey, thank you, Sarah.
Great. Thank you very much, Sarah. Just to kick off here, Sarah's right. When we first started thinking about this presentation 2 years ago, it was a little more toned down, talking about FIDO, but then in looking at, some of the topics we were going to be talking about today, getting into nuclear verdicts and the reptile theory, Dale and I decided, we're going to jazz this up a little bit more because, really, when you stop and think about it, when you look at liability claims, we've got nuclear verdicts that come about from auto accidents or, the building that collapses, and not to minimize those, but from a parent's perspective, imagine a scenario where your young son or daughter is attacked by an animal. It's very heart-wrenching when you stop and think about that. Now, it brings up a whole host of issues, and Dale and I are going to get into those today. But when we're talking about, this particular topic, not all dog attacks are laughing matters.
Like I said, if you don't see it coming, you don't feel it. Okay. Okay. All right. So just lunge forward to me. Should I have my fist balled up right now? No, you can go like this and just keep your arms up. Okay. 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 1, 2, 3, go. Get off me. Get off the house. Okay. Oh, okay. 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 I'm standing still. I'm standing still. Down.
Now, it's fun to have, a little bit of joking around with this topic, but it really isn't a laughing matter. And when we go through our discussion today, we're going to be focusing on a number of different points. Oh, sorry about that. First and foremost is going to be, why do we care so much about these cases? You know, from an adjusting standpoint, from a carrier perspective. Number two, are there ways that you as insurers can limit your exposure on the front end? We're talking about the application process. We're talking about your policies. We're going to get into liability issues. And then we save what I call the best for last here, other challengers and challenges to your policies and any exclusions you may have. Some of these I think are going to surprise you. Some of you, they may not. But with that being said, why do we care? And with this, we're going to talk a little bit about the statistics, okay? And we've highlighted a bunch here. A lot of them are pretty self-explanatory. You can find these all over the internet. $797 million in liability claims or injuries were paid in 2019. That's a big increase from 2018. And we don't have the numbers from 2020 yet because unfortunately, they don't come out until the fall of that year. So come October, November, then we'll finally see what happened in 2020. You can see down here, the cost per claim also is increasing from 2003 to 2019. The cost of settlements, jury verdicts are increasing as well. Again, some more statistics here about what these all mean for us in terms of the average claim payout. Now, I know we have more statistics because there are some in the crowd here who I know like numbers and you want to be able to see where these are going. 4.5 million dog bites occur every year. Nearly 1 out of 5 of those bites becomes infected. Translation, you're going to probably be seeing more in terms of medical bills or expenses when they become that happens. 300,000 plus emergency room visits because of dog bites. And probably one of the most disheartening ones to me as a parent, over 30,000 of those instances involve children between the ages of 5 and 9. Now, I want to take a brief pause and kind of talk about these statistics, talk about the claim payments. Dale, do you have any insight or want to chime in here as to why you think those might be increasing?
Sure. Yeah. Thanks, Scott. Well, when I started in this business 5-6 years ago, actually more like 35 or 6 years ago, dog bite claims were looked at with some, they just weren't given much respect. These guys handle dog bite claims. I'm not too worried about that. It's just a dog bite. I'll take that. No big deal. But these cases have become real cases. And one of the reasons for that is because of the nature of the injuries. And as Scott alluded to, I mean, a hand bite is not a sexy claim. I do some dental malpractice work. A bad tooth is not a sexy claim. It just does not generate a lot of emotion with the jury. And you get that same sort of thing with a bite on the hand. But unfortunately, what happens in these cases a lot of times is that the injuries turn into a whole lot more. As the statistics indicated, a lot of these end up with infections. And I know some of the people that may know me know my cat scratched me a few years back, and I ended up in the hospital for a week with an infection on IV antibiotics. And so what started out as a scratch turned out to be a week of hospitalization and bills, and it turned out to be a big thing. But that is the case often with animal bites of any kind. And it's certainly the case with a dog bite. And I've seen in many of the cases I've handled that indeed, infections become an important part of the case. Sepsis can be an issue with those infections as well. And again, the value goes up, kind of in keeping with the social inflation discussion this morning. The numbers just keep getting bigger and bigger. I've seen also cases where maybe not so much with the attack itself, but even a plaintiff will be trying to avoid a dog coming at them, and they'll fall and tear their rotator cuff, or there'll be a hip injury, or it'll turn into something a lot more verifiable, for lack of a better term, where you actually are suffering a verifiable injury. You're in the hospital, you're having operations, it's turning into a real case with some real injuries. And as Scott mentioned, one of the main things in these cases is that typically, well, maybe not typically, but often, the plaintiff is a small kid. And certainly there's going to be a lot of sympathy in those cases for the child plaintiff, and for their parents for that matter, who are bringing the suit. There's some opportunity to look for comparative negligence in these kind of cases, but nobody's going to assign, no matter what the kid did, nobody's going to assign a 4-year-old much comparative negligence. The kids that are victims in these cases are typically defenseless. They end up with scarring, horrible trauma, and very significant damages. So these cases, you think dog bite, you may not think immediately it's a big deal, but the types of injuries that flow from these turn out to be fairly significant at times. So it's something we need to pay attention to as the lawyers and as the claims handlers on these cases, the nature of what can result as a result of a dog attack or a dog bite. Scott?
Yep. Now, one of the things I would love to be able to do if we were all in the same room together out in Gettysburg, looking at each other live, is ask the group, who in the crowd here today has ever been bitten by an animal before, whether it's a dog, a cat, a parrot, you name it. And the reason why I would ask that question is because for those who haven't, it's kind of hard to understand what's happening at that moment here. And let me just go back for a moment, and I'm going to put on my best version of Estelle Getty from the Golden Girls, for those of you who may remember that show here. All right. And we're going to say, picture this, New Year's Eve, 2002, a handsome young lawyer is a year into his marriage and is going with his wife into upstate New York to spend some time with her sister and her husband. Couple brings their dog up. The sister-in-law, or his new sister-in-law, has a dog of her own, and his dog's sitting another dog. Well, unfortunately, two dogs don't get along together. So the handsome young hero goes outside to see what's happening, and the dog that the sister-in-law was watching is exceptionally aggressive, the kind that you see in like a Cujo movie, and latches on to our hero's hand. Now, Dale said dog bite or hand injuries for dog bites, they're not that sexy, but let's walk through this and let me see if I could paint a picture. And this kind of ties into the whole reptile theory a little bit. So we're crossing it here. The dog bites on to the hand, one canine on the bottom, the other, its mouth big enough, right over the top. The bottom bite goes right to the bone, and the top goes right along the nerve in the hand, and it's latched onto it. And you remember that video in the very beginning? I made a little bit of joking about it. You see The dog is shaking its head back and forth. Every time the dog pulls, it's another physical injury where you feel the skin tearing, the bones popping out. Very painful. What does someone do in that situation? A 5-year-old may handle it differently than a 21-year-old can handle it. There's scary situations to be in as well. How do you handle that? The injuries you have afterwards, sitting there in the hospital where, okay, if you get into an auto accident, you're a little broken up, but having then the medical staff have to go through and clean out open wounds, that go down to the bone so you don't get the infections Dale was talking about. Now, those claims, you're going to have the dogs, the cats, whatever the animal is, but dogs mostly, as these wild, ferocious animals, and the owners as almost the enablers. They're going to generate a certain amount of fear by their very nature within the minds of the jurors. Now, the dog that did the biting in this case, we'll call him lucky. Just say he didn't turn out to be so lucky afterwards. And our hero went on with his life and has a good working hand here. But the way the cases are being portrayed now, these fit so nicely into that reptile theory, nuclear verdict, social, whatever you want to call it, inflation of verdicts, that it doesn't take much to get to that point. Now, what can we do on our own? That's right. And one of the comments was claiming post-traumatic stress has almost become a standard with dog bite cases. You're right. You're absolutely right about that. And it's something that needs to be explored during the course of any claim litigation. Now, what can insurers do on the front end when dealing with these? Is there anything that can be done? Well, there's 4 key points here that we're going to talk about, but let's just start with the most typical scenario we see. Your first notice of this is either going to be at the time of renewal in the application or at the time of the claim. Now, the question, and here's a question that's out there, and it's one that is sort of generic and everybody deals with: can a carrier simply decline to renew, cancel, or increase the premium because the insured adds a pit bull or German Shepherd to the family? And we chose those 2 on purpose, but you can fill in the name of just about any dog there, because the answer is going to be the same. And it's maybe, but only if you can show that it increased the risk. Now, that's always the catch, isn't it? Because, attorneys love to cite to the Unfair Claims Practices Act. And when you can or cannot cancel a policy, it has this language there. Okay, we can all read it. We probably have read it and know it 100 times by now. But what does this mean in practice? Let's get to that part. Okay. Back in 1979, the Pennsylvania Commonwealth Court basically said it just can't be because of the nature of the dog. That alone is not an increase in hazard. Okay, you need something more than that. Okay, and in this particular case, it was a German Shepherd, and the court was unwilling to go and say that just because you have a dog like that translates into a substantial increase in risk. Now, in fairness, since 1979, there's a whole host of statistics out there linking certain breeds to certain propensities and certain behaviors. Information you just didn't have available back in the late 70s when this decision came out. But we are still seeing other guidance from the courts. The standard that's come out, okay, what we've kind of digested from all of these cases is whether or not a dog was provoked into aggressive behavior is the standard when you're determining if a dog represents an increase in hazard. Okay, so if you know the dog had prior bites, what caused them? For example, in one case, the court found that an increase did not exist where the dog bit someone who entered the property, and basically a trespasser, and the gate had a big sign that said, "Beware of dog." Okay, no increase in risk there. Okay, second situation where you have the child who was bitten after a dog was just given its dinner, and the dog had never shown aggression before. Again, no increase in risk. And if anybody wants the case sites for these, I'll be happy to provide them. Just send me an email afterwards. However, you can see the first question came up here today. All right. Now, an increase did exist where the incident was the third in which a particular dog had bitten people before. Similar situation, an increase existed where you had, in the last case, a Rottweiler left the owner's property, followed somebody, and then attacked the person. Okay, so what was the dog doing? Now, the better way to deal with these is going to be, let me back up before I jump ahead here. This is a question that we sometimes get, well, is this insurance fraud? Is there fraud in the application? Now, if you can prove that the insured knew the dog had a history of attacking people and purposefully withheld it, legally and academically, you could say, yes, that's fraud in the application. But the reality is, in the context of a third-party claim, where you have someone who's wholly unrelated and unconnected to the insured household, which is where the vast majorities are, that's not going to mean or amount to anything, because nothing that you can really do to the insured is going to limit your liability to the third party here. Now, there was a question that just popped up about whether we can limit exposure for owners claim that the dog is an emotional support animal. We're going to talk about that. So hold that thought. That's going to be the fun part of the presentation. But before we can get to emotional support animals and some of the other coverage issues that are going to arise, since we kind of talked about the beginning part, the statistics, the application, this is going to be a good time for us to kind of change gears. And I'm going to turn this over to Dale to talk about the liability issues that he's seen, he's familiar with, and how the law has changed with regards to those.
Okay, thank you, Scott. Yeah, I'm going to talk a little bit about the liability aspect of these cases. And then Scott's going to come back with some additional insurance coverage and exclusion issues, and talk about the support animal issue that was just raised. But did want to talk a little bit about the liability issues in these cases. Bottom line is that these are still negligence cases. There we go. These are still negligence cases. They require a duty on the part of the defendant. There has to be a breach of that duty. There has to be causation, and there has to be a harm. Now, these cases used to be a lot simpler. in the olden days, Pennsylvania had the one free bite rule. I'm sure many of you have heard of that. Basically, the argument or the theory was that, boy, if somebody, a dog owner, did not know their dog ever bit anybody before, how can they be responsible for preventing the next one? Nobody was on notice that their dog was bad until they actually bit somebody. And that was the case law for many, many years, as early as the Pennsylvania Supreme Court in 1936. And Andrews basically had that as the position of Pennsylvania on that issue. On the criminal side, and we're going to talk about the Pennsylvania dog law, which has some civil components, which has some criminal components to it. On the criminal side, the big case is Aratano versus the Commonwealth. That case involved a plaintiff that the child went over to a friend's house, was eating a piece of chicken. The friend's dog attacked, really going for the chicken, but ended up causing some pretty serious damages to the plaintiff's child. And the court said in that case, and this is before the amendments to the dog law, which we'll talk about, prior to the incident giving rise to the complaint, the dog had never exhibited aggressive conduct or bitten or attacked another individual. The requirements for declaring the dog dangerous were not met. So we have essentially the one free bite rule reigned on both the criminal side and on the civil side. So that was a lot simpler. But in the meantime, we've had case decisions on the criminal end. We've had some decisions on the civil end. We had a very significant amendment to the dog law, which confounded everything. So it's a little more involved these days. So we're going to go through a lot of this fairly quickly, but just want to give you some of the highlights and some of the issues that are out there. If you look at the Pennsylvania dog law, which let me get to the right page here. Yeah, the dog law is a huge sweeping statute that covers pretty much everything you can think of with respect to dogs. Requirements for kennels, requirements for licensing, municipal dogs. There is a confinement portion of it that comes up a lot in these cases. There's also a provision that's called the harboring of a dangerous dog. It's a criminal offense, and that is often raised in these cases. So it's a sweeping statute that covers everything. If you look at it, it would take forever to look at it in a lot of detail, but we're going to try to hit the highlights of it. The confinement law, and this is something that you'll see in a plaintiff's complaint in almost every case, that, oh, you failed to follow the confinement requirements of the PA dog law. Those requirements are that you have to have one of three things. You have to either have the dog confined on the premises of the owner, and there's some case law out there whether an electronic fence is sufficient for that purposes, for those purposes. The dog has to be on a leash or collar or some other restraint device so that he's under control. And if you got a situation where it's a hunting dog or a dog in training, there has to be some type of control over the dog. You can't just let dogs run wild. Virtually every plaintiff's complaint in these cases are going to have some reference to that section. Another very important section here is the summary offense within the dog law of harboring a dangerous dog. Complaints will say, they'll go through the essence of the requirements for that summary offense, whether there's been an adjudication or not. The complaint will say, oh, you had this dog, he had a history, he had a propensity, he did attack. A summary offense here requires a number of things. For purposes here, we're going to look at the main items. It requires either four things. It can be the dog needs to have inflicted severe injury on a human being, on public or private property. And technically that would not have to be an attack. They've killed or inflicted a severe injury on a domestic animal. They've attacked a human being, or they've been used in the commission of a crime. And you'll note that I've highlighted a lot of these provisions have without provocation, because if there is provocation, then it kind of changes things. The statute, the summary offense would not have occurred if there's provocation. So we look at these requirements for there to be a violation of the dog law, and typically you'll see in a complaint some variation of these requirements. What becomes a little trickier in these cases is that in addition to that, for there to be a violation, there has to have been a history on the part of the dog of attacking people or animals, or a propensity to attack. Now, until 1996, when the dog law was amended, the propensity to attack typically was very similar to having a history. But the language added in 1996, which is shown here, a propensity to attack may be proven by a single incident of the conduct described in paragraphs, the 4 instances on the last slide. So a single incident can be evidence of a propensity to attack, even if the dog had never attacked anybody in the past. If you have one single incident, that can be evidence of a propensity. And so you can have a violation of the dog law if that occurred. And again, plaintiffs are gonna cite these provisions of the dog law, whether there's been an adjudication or not. The statute itself requires a magistrate to find that beyond a reasonable doubt, these elements have all been met. And in fact, the dog law defines dangerous dog as one that has been adjudicated as dangerous by a magistrate. So there are requirements. They're typically ignored by plaintiff's counsel as they're filing their complaint, but the language is all there. It's information that you should be aware of. The language of the act itself, there's a lot of ways you can get around it. You can defend against it. One of the main ones is a provocation. If somebody's teasing a dog or doing something to bother the dog, the harboring a dangerous dog may not apply. The facts of your case obviously are going to be widely varied. Wasn't it an attack and fits under one of the sections? Was there a severe injury, which would be required in one of the sections? And again, the history of propensity. So you can look at the language of the Harboring a Dangerous Dog Act and try to defend it in that manner. In addition, again, plaintiffs are going to ignore whether there's ever been a conviction. They're going to go through the elements of the dog law, either the confinement portion of it or the harboring a dangerous dog portion of it as part of their complaint. And as we'll see as we go along here, there are some cases that can help in that regard for plaintiffs. But probably one of the first things you want to look at is whether the dog law is applicable at all. It does not apply if there's a willful trespass or other tort being committed by the would-be plaintiff. It doesn't apply if the plaintiff is tormenting, abusing, or assaulting the dog, or has done so in the past, such that the dog would recognize this as somebody that's going to bother them. And certainly if the plaintiff is committing a crime at the time, the dog law would not apply at all. So that's probably the first hurdle that needs to be gotten around by plaintiffs. So again, you look at the language of the act, specific cases, specific provisions may or may not apply. It's all very fact specific. Some of the case law involved in these on this issue, like I said, it goes back and forth. There's criminal, there's civil. Probably the first case in the civil end that really said no more one free bite was Miller v. Hearst. That's a 1982 Superior Court case. That case involved, as pretty much all of these cases do, that case involved a dog attacking a child. The plaintiff allowed their dog to roam free. The Miller court looked at Andrews, the old cases that talked about one free bite, and they said, we can't do this anymore. They said, because of the urbanization of society, dogs cannot be allowed to run free with no responsibility for damages caused. An unexcused violation of the dog law is negligence per se. And they're talking at that point about the confinement provisions of the dog law. And shortly after that case was decided, the language in the statute was added to talk about a single incident. So this case is often looked at as either being narrowly interpreted. It just talks about the confinement portions of the dog law, or you look at it in a broader sense, even though this was decided before those amendments, should it apply to the amended dog law, which talks about harboring a dangerous dog, can a violation of that be seen as negligence per se, which is what plaintiffs are going to argue. And we've looked at the language. After the other cases, and I won't get into them in too much detail, so we don't have a ton of time, but the one free bite and the single incident issue has developed over the years. Commonwealth v. Hake basically said where there's a severe injury, this was a case under the criminal side of things. They were trying to show that the defendant in that case had harbored a dangerous dog. One free bite rule was abandoned in the criminal side of things. Even so, courts were somewhat reluctant to try to apply this on the civil end, and they did not want a single incident to be determinative of responsibility on the civil end, because that was in the criminal statute. So cases danced around the issue. Rosen v. Tate was a lower court case, which basically said, yeah, you can look at the criminal statute. It may prove a propensity, but you have the opportunity to show a defendant has the opportunity to show other evidence that indicates that it was not a propensity. So it's not conclusive. So the case that's often looked at by plaintiffs as their position that it just abandons one free bite, one incident can establish everything, and it's all negligence per se, is Underwood. That case involved actually a pretty nasty case. Plaintiffs, the defendant's dogs escaped from their apartment, rented home. They escaped, mauled a small child. Couple passers-by in a car stopped to try to help. They started getting attacked. The child was able to get a hold of her mother, who called paramedics, and they were finally able to stop the attacks. It was a horrible case, much like Scott had been talking about early on. The exact kind of case you dread when you think of this issue. But they said, well, the confinement statute can serve as negligence per se, but you do have the opportunity as a defendant to show that you weren't negligent. My leash broke. I wasn't negligent. A car ran into my fence and opened it up and the dog got out. I wasn't negligent. So you can still show, you still need to show causation. And if you weren't negligent, you would not have been the cause of the incident. The court also looked at the harboring a dangerous dog aspect of the dog law and basically said again, yeah, that can be seen as the standard, but it's somewhat in keeping with the case mentioned before. It's evidence. It's not absolutely conclusive, if there's that one incident means a propensity, it's evidence of it. I think there's still room under the opinion in Underwood to find that a defendant can provide evidence that something else contributed to the incident, not just that one incident, and can show that there was not a propensity. So those are the arguments. One other thing I wanted to mention, there is an allowance for assumption of the risk in these cases. The case is cited here is a lower court one, but it cites to an appellate court decision. This case involved a veterinarian's assistant who was attacked by one of the dogs. And the argument was, well, by the plaintiff or by the defendant, was that the plaintiff assumed the risk. The plaintiff assistant assumed the risk. They're working at a veterinarian's office. And the court basically said and relied on Groner, cited there, that, well, we don't have a clear rule on a veterinarian's case, but there's still the option of asserting or the ability to assert assumption of the risk. And they cite a case where a housekeeper knew that the Great Dane that the owners had would knock you over if you got too close to them. They knew about it. That is something that can be asserted in these cases as part of the causation issue. We can go into these in lots more detail, but just trying to hit the highlights on these, look at the issues that are out there. One other thing I wanted to touch on is landlord out of possession. The Underwood case actually involved that. Rosenberry is another case. Those cases, and a lot of the carriers here represent apartment owners or house owners where they rent out apartments or rent out houses, and they're dealing with a landlord out of possession where the tenant's dog gets away and does damage. The case law is pretty specific on this, that the owner, the homeowner, the landlord has to have actual knowledge of the dangerous dog and that the dog is dangerous. It's not a know or should have known situation. There needs to be actual knowledge on the part of the landlord. Not only that, the landlord has to have some means or method by which they can control the situation. They can either evict the tenant or get rid of the dog. If there's a provision in the lease where you're not allowed to have a dog, we can kick you out if we find that you have a dog, or we can evict you if you have a dog that causes problems, or a dog that, if you're violating the Dangerous Dog Act, if you have some kind of criminal conviction, we can evict you. If there's something, you need to have something like that in the lease. And the Underwood case and the Rosenberry case cited there, they involved landlords that basically had complete control over the tenant. I think the tenant in Underwood was the owner's niece who didn't pay any rent, and pretty much the landlord had complete control. So you need to have actual knowledge and you need to have the ability to control. And I've seen some recent lower court decisions where there may be some requirement for seeking some kind of injunctive relief on the part of a landlord if they know that there's a dangerous dog. So that's something that's still developing. A couple other things in these cases, and I'll wrap my part of this up in a moment here and let Scott talk about the remaining issues. But one of the things that arises in many of these cases, almost all of them, is that people love their dogs. Their dogs, their German Shepherd cannot be a bad doggy. They do not want to admit that they may have a dangerous dog. And as a lawyer and as a claims handler, that's something that has to be looked at. What is a jury going to think when they look at the evidence? I had a case where the clients told me that, yeah, the dog in question here, they got into a scuffle over a toy with my other dog. It was no big deal. We get veterinarian records in later that showed that the other dog had damaged kidney, had nerve damage, had sutures, the dog was mauled. Same case, we were told that they've kenneled the dog many times, no issues, no big problems. But you find out from the kennel owner that, yeah, there were no problems, but we had to keep the dog segregated because we were afraid there was going to be an issue. So you have to look at the credibility of the dog owner or keeper in evaluating these cases and evaluating if there's going to be some potential liability. Another case we had during the course of litigation, the dog owner put the dog down. And certainly that is going to lead to the question, why did you put the dog down in the middle of this litigation involving an attack? Certainly that raises some credibility issues. Potentially there could be some spoliation issues. That dog can be evidence. Perhaps at some point, somebody wants to look at the dog. And so if you've destroyed the dog, you may have destroyed some potential evidence and could lead to a charge that is negative to your interests. I had a weird case where plaintiff argued that, well, yeah, the plaintiff was a trespasser, but once you realize as the homeowner that this guy was a trespasser, you had a duty to stop your dog at that point because you could see he wasn't going to cause any harm. That case, that got nowhere, but it's something that plaintiffs are going to argue, ways around these issues. Another one, oh, it wasn't my dog, it was my girlfriend's dog. The case involved the girlfriend moving in with the husband or with the boyfriend. She brought the dog with her, the dog attacked somebody, and representing the boyfriend, the argument was, well, it isn't my dog, I'm not the owner. I own the house, but I'm not the keeper of the dog. And you get into issues of who the keeper was, who the owner was, and what actually caused this case. Was it something the homeowner did? Was it something the dog owner did? So those are the kind of issues that can come up. Punitive damages, and that's the last thing I'm going to talk about. These are basically the same issues as you see in any type of case. Is there wanton or willful misconduct? Essentially, does this dog have a history that should make a defendant aware that if they don't do something to control their dog, problems could ensue? So it's going to come down to knowledge and whether whether there's a propensity proven under the Harboring a Dangerous Dog Act or not. What did the defendant owner know? What did they do? Was there a history? Those are the kind of issues that are going to be looked at for determining if a punitive damages claim can go forward. So with that, those are the takeaway issues here. We've covered them all. I don't want to take up any more time here. Let Scott take back over here, and thank you for your time on this. And there's a lot of issues in these cases, and try to run through them kind of quickly. Please feel free to contact me if you have any questions on anything specific or anything that time required kind of glossing over. So thank you.
Great. Thanks, Dale. Before we leave the liability focus, let me throw a couple other things out there that Dale and I had talked about beforehand. One is other third parties. And this is certainly something that I think you need to keep an eye on during any claim investigation involving a dog bite. For example, one of the takeaways that Dale mentioned beforehand was, the owner saying, well, I had a trainer. You should find out, was the dog boarded at any place recently? Did the owner take the dog for training at a certain place? There are lots of people out there who do it. Dog walkers. Did the owner have a dog walker who may have taken the dog to a park or someplace else, and maybe there was an incident there? But you want to try and look for other places where liability could lie for the dog's behavior that generated that propensity. Okay, great case in point. My first dog, we brought her to a place, like one of those doggy daycare things occasionally. Well, one time, picked her up, something was wrong, followed up with her. She just wasn't acting quite right. Found out there was an incident at the kennel. Now, my dog, after that point, didn't like other dogs. So we didn't put her near other dogs because we didn't want to have that situation arise. But if we're talking liability and a defense in a litigation, you need to explore that. You need to explore it, even if it's an emotional support animal. Now, I'm going to talk about that in a little different context in a moment, but if you have an owner who, bought a dog or an animal because it was supposedly an emotional support animal or some type of, assistance animal, you got to look into where that came from, because with emotional support animals, they're not regulated the same way that your assistance animals are regulated. You want to find out how that dog was trained, how it was raised, see if there's any issues there. Now, coverage issues, I'm sure there are some people out there at this point kind of scratching their head saying, this is great, I'm glad I'm getting my CLE credit, but guess what? We have exclusions in our policies that mean we don't have to deal with these claims. Insured, you're on your own. If you have a dog and it attacks somebody and there's damage, bodily injuries directly or indirectly. But I also know that there's a lot of carriers out there in PAMIC who may not have these types of exclusions. So I would encourage everyone, if you don't have a dog bite or dog exclusion in your policy and you're interested in one, we have some samples here. Download the presentation and you can take a look at them and decide whether this is a direction your company would want to go in or not. There's two right there. There's some other exclusionary language that we've come across in other situations. Okay. Again, you can pull the PowerPoint and see this. And I'm kind of skipping over this a little bit because I want to get to this last point. All right. Because number one, it's true that there's no Pennsylvania appellate court that has overturned a properly applied canine exclusion. But what happens when either your insured's dog or the tenant's dog is a service animal? Okay, now that raises some really interesting problems potentially. And that's going to lead us to what I'm going to call the other challengers. Okay, now I'm sure there are some out there looking at this going, HUD, what in God's green earth does HUD have to do with dog bites? Really simply, believe it or not, there are instances out there where insureds have made the claim that they can't rent to a place or to a tenant because maybe their insurance carrier, or let me restart that over. A homeowner will not rent to a particular tenant with a dog because they're being told their insurance carrier will not insure dogs. Or better yet, you have an insured, someone who applies for insurance, gets it, and then you as the carrier say, this is an increased risk, we don't want to insure you. And the insured says, well, I have a right to this service animal because it's guaranteed to me under the HUD's regulations, and your exclusion is void as against public policy. Now, it's our last question for the day here. If you want to answer that real quick. And if you're watching my screen, you're going to see me click yes. Okay. Now, the question that's going to be asked to the carrier is, have you made any efforts to give a reasonable accommodation for the use of a support animal? And there's case law out there that talks about a reasonable accommodation has to include an emotional support animal. Now let's take a step back. The attorneys in the room, I'm sure there are some saying, carrier can't even be sued by HUD. Maybe, maybe not. The answer is unclear. There's a single case that's out there where it was granted in the context of insurance rate setting, but the court said that a carrier could be subject to jurisdiction for violating the Fair Housing Act. The limits and bounds of that have not been tested by any other trial courts or appellate courts to my knowledge, but we can't say definitively the answer is no. I think the extent to which you see HUD getting involved is going to largely be driven by the politics behind it. But let's put that aside and just go with this for a moment. If the Fair Housing Act can encompass the use of a emotional support animal, and you don't allow an insured to have that, do you run a risk? The answer is going to be maybe, okay? Those hearings are conducted entirely different. It's similar to, I would call it the going before the Department of Insurance as opposed to an actual litigation. But it's possible. Now, to prove a denial of a claim for reasonable accommodation, the plaintiff has to show 4 things. Here's what they are. Now, I also want to throw this out there as well, okay? Because just like we have the proverbial ambulance chasers and the people setting up yourself on the liability side, there are organizations out there, one of which in New York is called MOVE, that their sole purpose is to try and trap landlords so that they can get claims paid for violating HUD's regulations. So this is a very real issue, even if you haven't seen it. And they're not just limited to New York. They're in every state that I'm aware of here. Okay. Now, what is the defense to these? Okay, how do you defend these? Okay, and I've been involved in, some of these types of actions before. And the way to defend against these is really going to come down to what was actually said to the insured, okay, and what was said to the carrier, because a lot of times you have to show that there was no request made of you, the carrier, for a reasonable accommodation. Okay, take my landlord example. Landlord just says carrier won't let me rent to anyone who has dogs, but never goes back and says, hey, I've got someone here who needs this accommodation because of a disability. If that doesn't happen, then odds are very good you're going to be able to get out of that without a problem. Okay, we've seen HUD try and make wholesale, just flat out void a dog bite exclusion or a canine exclusion in a policy. And there's enough law out there supporting those types of exclusions that I'm confident enough to say in front of everybody here, that should not be a concern in terms of a public policy argument. It's going to be a very fact-specific inquiry. Now, there is one question here. To be considered a service animal or emotional support animal, do the owners need certifications? And the answer is going to be for service animals, yes. For emotional support animals, largely the answer is no. That's why you read some crazy stories about people who will have an emotional support iguana or a camel, is their emotional support animal. It's much less regulated, and then it makes it much tougher to be able to come in and say, as a landlord or a carrier, someone who's asking those questions, why do you need it? Can you legitimately ask questions about their medical condition? It gets dicey. I would say you got to talk with people very carefully about the types of questions you ask, because there's a way to get the information legally, and then there's a way that potentially opens you up to some more headaches and the need to go buy some Pepto-Bismol. Now, with that, thank you very much, Sarah, and everybody, for allowing Dale and I
Thank you, everyone.
to talk to you today about this.
Well, thank you, Scott and Dale. It was a really interesting presentation. Gosh, there's all sorts of puns that come to mind, and I was so tempted, and I will not, none of them are going to happen. Okay. Thank you very much. And thanks to everyone who registered and participated in PAMIC's first and last virtual claims summit. Look for a thank you email and a survey link. And please be sure to give feedback. I guarantee that it's going to be used in planning the 2022 Claim Summit. Once again, thanks to all of our sponsors whose financial support made this possible, to the claim committee members who worked diligently to put the program together, and to Ron, Andrea, and Brittany of the PAMIC staff. All the presentations we've heard have been recorded, and a link to re-watch them will be available on the PAMIC website to all attendees. And it's not too early to consider joining the claim committee when the call goes out later this year. It's a valuable and interesting experience, and I encourage you all to seriously consider it. And I'm looking forward to seeing you next year at the in-person 2022 Claim Summit. Y'all have a great day. Take care,
everybody.
Thank you.
Yep. Bye-bye.